Um, and, oh, Philip, and hopefully you're doing better today. You look
Yeah,
healthy.
I'm not 100%, but 90, I
That's
guess.
good. Means
Yeah.
it's working.
Yeah.
It's dated February 13th, 2020. It was on H808 constitutional parameters on law enforcement use of force as a subject. And it discusses the Graham case. Came up
Dick,
yesterday.
where is this document? I don't see it on the website.
Should be on, it's on our web page from yesterday's documents.
It is?
for
I don't think I
yesterday.
ever
Oh, I'm
got it.
sorry. Yeah, it's an email sent to the committee by Bryn, but it could be on the website.
Email, okay. Cool.
Okay.
It is not. I don't think I got it. Do you want to send it to me, Bryn, and I post it?
Sure thing. I'll send it.
I can get it out of my email.
At any rate, it goes through the Graham case versus Connor. And was that Lindsey Graham?
That's a great question. I gotta check. I don't know.
That's, yeah, just South Carolina court.
Oh.
Bryn, what's the reason behind going to this case? I missed the second session yesterday.
So the committee yesterday was talking about the existing constitutional standard for what would constitute a violation of the right to be free of unreasonable search and seizures. So we were talking about the Graham case, which is kind of the foundational case that still governs today for law enforcement use of force. So this, I shared with the committee a memo that I drafted way back in February last year. It feels like a very, very long time ago.
Yeah, 2020.
Another lifetime. So it was just a sort of an introductory memo to the existing standard that govern use of force claims. So that's why I shared it with the committee, because there were some witnesses talking about the Graham standard, and the committee started discussing how H145 and the existing Act 165 is really a codification, essentially, of Graham, plus some additional standards as discussed when you were working on Act 165, including the requirement that force be proportional and deadly force be necessary.
The testimony from Mike Sherling and some others was to add clarity to B, use of force on page 2 and 3, B1 and B5, and Sherling wanted, if feasible, in there, and there was quite a discussion about whether or not we needed to clarify it, because 5 is based on Graham, and that's where the discussion.
Mm-hmm.
They also talked about using adding without hindsight, which is part of the Graham case, and that came from both Sherling and Julio Thompson.
Bryn, I remember you sending an email yesterday talking about that last passage and saying that it was already conditioned on a previous subsection.
Are we talking about the to the extent feasible, or
I think it was the
Hindsight.
without the benefit of hindsight?
it was the one that begins when the officer page 3 subsection 5.
Right, that's what we're talking about.
Yeah.
When an officer knows that a subject conduct is a result of medical condition, mental impairment, blah, blah, blah.
And I was arguing that was already conditional, and you wrote an email that pointed out that it was already also conditioned on another piece.
Right. So we, the committee, I testified to this yesterday. You must have had to hop off. I'm sorry to be repetitive for the other members of the committee, that the B5, the language that requires that a law enforcement officer use information that he or she knows about the subject's conduct. That is the way I described it is B1 is the standard that the court is going to use, the standard that by which the court will judge all cases that come before it that have to do with law enforcement use of force. That's the standard. That's the Graham standard right there. And so all of the following provisions under B1 are various directives to law enforcement. But any use of force case that appears before the court is going to be judged by that standard. And B1 is the standard, is the feasible and reasonable alternatives standard. So a law enforcement officer's use of force is going to be judged based on whether or not feasible and reasonable alternatives were available to the use of force. It was my testimony that that feasible requirement already exists because it's built into the standard that's set out in B1.
Right. Thank you. I remembered that from your email. So I don't know why we would add if feasible at the beginning of that.
No, I think
subsection
that
5.
I think that the ultimate decision was if it's added, it would be added in the last clause there. The officer shall consider that information when determining. The officer shall if feasible, consider that information, because I think Julio, one of the things he said is that and I think that Bryn disagreed with this, and I'm torn, but what he seemed to indicate was that if the court said if there was a case and the court said, did you consider his mental condition or whatever before you acted? And the officer said, no, I was shot, I didn't have time to consider it. Then the officer has violated the state statute because he didn't consider it, because it says there shall consider.
But it only says that they have to take it into account.
Yes, but what he was saying was that there are instances when you don't have time to take that into account. You're shot and.
Well,
Yep,
I think he didn't say you were shot. He said they've opened fire on you. You're a police officer. Somebody's opened fire on you. And is it feasible at that time to take into account the mental condition of the person who's shooting?
Right. That's what he said, yeah.
In the case that he described, though, the officer had been shot. He was wearing a bulletproof vest, but he had been shot at the door and he fired back and the fellow who shot him died. And so when he was questioned, it was, did you consider it? And he said, no, it was immediate reaction to.
But if we go back to B1.
In B1, they would like benefit of hindsight.
Well, in B1, I would say that already covers what the situation you're talking about. It's not feasible to use because you're shot. So in other words, I feel as though what Commissioner Sherling would like is as many repetitions of the phrase if feasible or when possible, because it serves overall to weaken the guidance in the law or the mandate in the law. But I mean, I feel as though it's pretty clear, and I think I hear Bryn agreeing with this, that's already covered in the language. And the House didn't add it, I would assume, because they didn't see a need for it. So, I put it this way. If it's a trade-off between hindsight and adding if feasible, I would prefer if feasible rather than in hindsight, because I feel like, as I said yesterday, the in hindsight piece sort of leads to an interpretation that the defendant, it sort of leads a retrospective consideration in terms of a defense for someone brought under that statute. So again, if it's one or the other, I would prefer it to be if feasible, although I think it's redundant.
Well, I think that it was in two different places though. He didn't
Yep.
put if feasible. So, and I would like to have Bryn just comment on the case that Julio talked about. That if the guy is questioned, and it says here that the officer shall take that information into consideration, into account, when determining the amount of force appropriate. If the guy, in the case that Julio used, the guy is shot, the judge says, did you take his mental state into consideration? And the guy says, no, I didn't. I was shot. I had to do something. That Julio's contention is that he has now violated state law because it says they shall take it into consideration, and that a sworn officer has to uphold state law. So that's where I'm having a hard time here.
Sure. I think that what I testified to yesterday is that I think that perspective is looking at B5 in a vacuum. It's looking at B5 as if it exists all on its own, which it doesn't. It's a part of this new whole section of law, which is 20 VSA 2368, standards for law enforcement use of force. And the way that the statute is set up is that it provides first it's definitions, and then subsection B says, here's the use of force standard. And the first subdivision under B, use of force standards, is the test that a court is going to use when it is determining whether or not a law enforcement officer's conduct was reasonable. So, and the test specifically provides, second sentence, a law enforcement officer's failure to use feasible and reasonable alternatives to force shall be a consideration for whether the officer's conduct was objectively reasonable. So that's where you get the question. The court's going to ask the question, was it feasible to use an alternative to force? If it wasn't feasible, that's going to go towards the court's analysis. So I read this as I'm reading it holistically, because I think that's how a court will look at the statute. I think it will look at the statute holistically, and it won't look at each individual subdivision on its own. And I think that if you're worried that the court will look at each individual subdivision on its own, then I think that you should include that language in each and every one. I don't, I think you should. I think if you hone in on one of them for the inclusion of the additional language when feasible, you may want to look at each individual subdivision to make sure that you don't want to include the language there. Because it's just my position that if you add those words in one place, then you are adding, the court will look at that. The court will assign meaning to every word that you add. So if you add it in one place and not another, then you should just think about the repercussions of that.
Mm-hmm. So, yeah.
Could you explain a little bit of prior to Graham? In your memo, you state, since Graham and courts review law enforcement use of force with an objective, reasonable, and standard. But prior to Graham, federal courts reviewed claims of excessive force by police through diverse legal standards, often emphasizing the officer's subjective mental state. For example, courts would look to whether the force was applied in good faith or for the purpose of causing harm. And so,
yeah, I was just trying to
wouldn't adding some of this verbiage put us back there?
When you ask that, do you mean when feasible?
Put us back to Johnson v. Glick, or the good faith. If you use in hindsight in terms like that, wouldn't you be moving away from the objective reasonableness standard?
Well, the Graham court was really the court that articulated that phrasing without the benefit of hindsight. I think the reason I put in that prior case law was just to sort of give a little bit of history of how courts dealt with these types of cases before Graham was decided, and to emphasize that the ultimate outcome after Graham was that courts started looking at what a objectively reasonable officer would have done in that situation, as opposed to looking at the individual officer and saying, well, did you have good faith? Did you have bad faith? So that's really why I set it up like that. And I think the testimony you heard yesterday was that the Graham court talks about what is objective reasonableness, and they emphasize that objective reasonableness is based on what an objectively reasonable officer in the same situation with the same information, how they would have behaved, how they would have reacted. So that's where without the benefit of hindsight language came in.
Okay.
And, as I think Senator Bruce missed what I said about the benefit of hindsight, which was just that I reminded the committee that when you were working on the definitions section of Act 165, you thought about the definition, you thought about without the benefit of hindsight language that Graham articulated, and tried to incorporate it in your definition of totality of the circumstances, since that definition means all of the facts that were available to the law enforcement officer at the time. So that's why I've testified that I don't think it's necessary to include that particular language. I understand that you did hear some testimony from witnesses saying that if you don't include it, it may be a signal to the court that you're moving away from Graham. And, I don't necessarily agree with that, because I think that you don't need to have every single phrase from the Graham decision in order to signal to the courts that you're using an objectively reasonable standard, especially if you've got a clear set of definitions that indicate to the court that the facts they should be looking at are only the facts that the officer had at the time.
I think,
I guess
go ahead. We get hung up here and then we forget section 4. We need to make some revisions there too, by the way. Well, go ahead, Philip, and then Jeanette.
I was just going to say, I think Commissioner Sherling was talking about these changes he wanted in terms of clarification. I don't see them that way. I think it's very clear as written. What he is seeking to do, I think, is to repeat and emphasize certain things by so that would be one way of looking at it, is to repeat for emphasis. Another way to look at it would be to weaken the ability of a prosecutor in these instances. And that makes sense from his perspective, that we would get those kind of suggested changes. I'm just saying, especially after hearing what Bryn is saying, these points are already covered there. But if we go in and we double down on them, we're essentially steering an interpretation of what we're writing.
So I keep mulling this over, and I still am thinking about the example that Julio gave us. And in the totality of the circumstances, it says, all facts known to the law enforcement officer at the time. The law enforcement officer at the time knew the guy was having a mental crisis. He knew it, but he still had to react the way he reacted. I mean, that in that split-second decision. So he knew that there was a mental crisis going on. So in 5, then, since he knew it, does that affect his defense of his action? Because he did know that the guy was having a mental crisis. I don't know.
Philip, you used the term yesterday, reacting to the sword.
Right.
And I keep getting this this thought in my head that when an officer is called to a location, if there's a mental condition going on or some developmental disability that is causing the incident, it's pretty common for the dispatcher to get that information immediately from whoever the complainer is. So the officer is on their way being forewarned that there's some kind of mental situation going on. But when the officer arrives there, he now has arrived there knowing that the subject's conduct might be the result of that situation, but he's immediately faced with someone coming at him with a knife or a sword. This shall has me somewhat nervous, and I'm listening to Bryn trying to wrestle what happens if I'm in court representing an officer who's now been charged with murder or attempted murder as a result. And what do you do with that information in the instant you're facing lethality? And I'm not
take it
sure.
into account.
Well, how do you take it into account in that split second when you arrive and you're defending yourself?
The point I was making yesterday was you take it into account, but it pales beside the other consideration, which is that the person is challenging you with a sword. So that's why I think shall take into account, it sounds strong because there's a shall, but it's actually incredibly weak. All it says is that you will take it into account. It's very difficult to prove that somebody didn't take something into account. And B1, so
just for the sake of the argument though, put yourself.
There's nothing.
So if you go to B1,
Yeah.
it covers exactly what you're talking about. It already uses the word feasible as the standard. So,
but it puts a burden on the officer, doesn't it?
yes, it does. Because the reason why we're passing this law is because people are getting killed by police officers. I feel like we forget that all the time, and we get locked into a mindset of, gosh, an officer might be wrongly accused, and so let's rewrite the law around that. The whole genesis of this was people with mental conditions being killed for no reason, and people who were black and brown being killed for no reason. And so what we set out to do was try to create a standard that would rein in abusive of use of force. But I feel like we constantly segue back to the horrible possibility that there might be a prosecution for someone who kills someone without needing to, just because they don't take into account the fact that the person is not in control of their mental state, or the fact that the person is black. I just want to point out that we talked yesterday about the training sequence in the Derek Chauvin trial. Just yesterday, they used the fact that he had been trained in the chokehold to defend him. So we were talking yesterday about whether we would lift the ban on training. There you go. That's what we're doing now, is seeking to weaken all of the already somewhat tenuous mandates that we've put in the last year. And I have a problem with that.
Let me.
Can I just comment that from my perspective, the one thing that we do know is that we have seen, rather than a de-escalation of situations, an escalation of situations. If you look at the case in Minnesota, you have a $20 bill. You look at the case in Georgia of the guy shot at he was allegedly drunk in his car at a Wendy's parking lot. He ends up getting shot in the back. We have an escalation rather than a de-escalation, not proportional to the event. So we're talking about an officer being shot at. In the case of Floyd, we're talking about a guy being not compliant. In the case of Georgia, we're talking about a guy who allegedly tries to take the officer's taser, I believe, or spray. So, I'm in agreement with Philip because of those two situations. When I look at them, we got already covered with the totality of the circumstances. So I think that, and it's also covered in number 5, makes clear that it's, the use of force. I think we're trying to get to a proportional use of force. If the officer is being shot at, obviously, that's much different from a person refusing to get into the police car and then being killed.
That is, but
It-
the one right here where the guy gets shot, and it looked like no matter what is the decision by anybody, he still will be, could be charged this way because it's unconditional. It seems like, no
The
matter what,
officer or
the officer. Yeah. I mean, I understand what Bryn is saying, and to just take it on faith that they'll do the right, that they'll look through this thing as carefully as she has.
well, it's a reasonableness.
I actually have to say that I, Philip, take exception to your characterization that the commissioner is trying to weaken this. I don't think that's true at all. I think that the testimony also came from Julio Thompson at the AG's office. And so I don't think, I think that really what they are driving at is clarity. And it might be confusing to put that in for clarity, as Bryn has told us, because it would be there and not in other places. But I think that saying that he wants to weaken this and kind of implying that it's for the defense of the law enforcement officers, I can't agree with you at all on that. And I do think that, as Joe just pointed out, the person is on their way, and they're already, what we heard from the chief of South Burlington yesterday was that they're taking into account the de-escalation methods on their way. The dispatcher gives them the information and says, somebody's having a crisis, got to go deal with it. So they're already thinking about that. But when they get there and they're confronted with the knife or the gun or the sword, they don't have time at that moment to take into account what they're going to, they may have all the best intentions in the world before they get to that point. I'm going to de-escalate it. I'm going to calm him down. And then they get there and the guy shoots him. And at that moment, which is what we're talking about here, at that moment, they're supposed to be taking that into account. So I can see it either way. I just don't want us to characterize them as wanting to weaken our position here.
Yeah, I want to kick in with that too, because we are beyond the conversation of someone who is being detained. That's not what this is about. The question here is whether or not an officer immediately confronted with lethality has to specifically say that they took into account information in that split second. And I'm not 100% comfortable. Bryn, I guess I'm going to come back to you and say, if the officer has been given information ahead of time and knows there is a medical situation happening before they ever get out of their car, but at the moment they get out of their car, if they are immediately confronted with lethality and don't take into account, because this says shall take into account the amount of force necessary, are they protected in your mind by subsection 1?
Our witness doesn't have much time. She's arrived.
Oh,
So if you could answer that question briefly, and then we'll come back to this discussion.
Sure. So it's been my position all along that because B1 articulates the standard that the court will use in determining whether an officer's conduct was reasonable, they're going to use the analysis of whether there was a feasible alternative for every situation, even a situation where an officer knew information going on to the scene.
Okay.
Thank you. Luzana, thank you so much for being with us. I know you're limited time. We look forward to hearing from you, and you're on 2 screens, so glad to see you in person.
Thank you. First, I have to offer my sincerest apologies for being late. I was caught up in another hearing, and
Yep.
then there's stuff after.
There's only so many things one person can do, and we're asking you to be in 17 places at once. Luckily, we're Zooming, so you don't have to climb stairs or run around to find it. Thank you for joining us for a few minutes on this.
Yeah. So I know that you all have already taken testimony from a number of witnesses on 145. You've heard the admin's position. You've heard position from a couple of the advocacy groups and of the other law enforcement, law-related groups. So I don't have a tremendous amount to add. I know that this is work that's been continued from last session, and so a lot of the major changes have already been made. I note that you all have had discussions about things like hindsight, feasibility, training on chokeholds, etc. And those are some of the things that I thought I could just pop in and weigh in on for whatever that's
Yeah,
worth.
please.
Okay. So on the question of training for chokeholds, I know there was it's an odd position to be in, right? We don't want people using chokeholds, but we're also saying, but if you really, really have to, then okay, you can. But also, we don't really want to encourage you to do it. So should we even be training on it? But if you're not being trained, you're not doing it right. And it's just so strange to think, well, there's a proper way to asphyxiate a person, right? So I understand the difficulty in that. I know that the ACLU has testified that they don't want to propose language to allow for chokehold training. I'm inclined to agree with that, and it's a difficult place to come down. It's difficult to come down on one side or the other here, but I think that the potential for increased use based on recency or the appearance of it being allowed through training outweighs the benefit we could get from teaching people how to do it properly. I don't know if it makes sense the way I phrased that, but I
Yeah,
hope
excellent.
that you know what I'm saying. Okay. So I would probably agree that it's perhaps best not to train on that. Yeah. Feasibility, I do note that DPS has testified that section B5 currently says that officers shall take into account if subject's conduct is a result of a certain list of items or conditions, and the proposal was to add when feasible. I personally don't oppose that. I don't think it's necessary, and I think it might be a little too permissive. I appreciate that clause in its current form because it requires taking certain things into account, especially like language barrier, which is listed in there and is very much a racial justice issue. So yeah, I'm not certain that feasibility is necessary there, but if it were included, I think the harm would probably be minimal. The last one I wanted to note was without benefit of hindsight, section B1. As it currently reads, it says that objective reasonableness is determined by what an objectively reasonable officer would do in the same situation. The proposal was to add without the benefit of hindsight. I know that others have already testified on this, and that phrases like totality of circumstances implies without the benefit of hindsight, and that the sort of temporal state there is implied. I'm not certain that it's necessary, but again, I don't oppose the addition of that language. I do recognize that we're talking about incorporating different standards from Graham, and whether the exclusion of one standard somehow creates a new standard in so doing. And I think you've heard from real experts who have weighed in on that. So I'll not give an opinion on that, but I do think that when it comes to that language, it's probably not needed, but probably won't hurt us if we include it. That's what I got for you.
Great. Any questions Burns done. Very
Thank you.
helpful. Any other comments on the bill at all? We were a little surprised at the word in section 4, the words burglary and robbery. And that troubles me a great deal, frankly, that I got through the House for that, because I'm thinking of that case in Georgia where 3 people killed the guy who was presumably going into a vacant house to get a drink of water, but may have. They thought he might be stealing something from the construction site, but there's no, I mean, even this seems to allow that.
Yeah, that was another curious note that I recall from previous testimony you all had received. And the tricky thing, well, first of all, with robbery, there's actual or threat of use of force, right? And it's usually against the person, so that's a little bit easier. Something like burglary is different. People often equate it with breaking and entering. They're different because there's an additional intent element to commit a crime inside the structure. So that makes it a little tricky, because if you think someone's going to burglarize a place, you don't know what they intend to do there. And if you kill the person, then you might just be killing for a normal breaking and entering, if there was no actual intent to commit a crime inside the premises. So it seems as if it is of great concern, and I think perhaps that language should be amended, because otherwise, I think the example used yesterday, like you were saying, the person broke into a shed. Is that really enough? And when we see so often people who are described as suspicious, one of the things that people tend to have in common when they're described as suspicious is they're often brown. And so I feel very uncomfortable with the leeway that could provide as written.
Several years ago, Bryn, we wrote a statute, I think it was under youthful offenders. We took burglary into an occupied dwelling and made it so that it had to be actually occupied.
Yeah, that's the expungement statute.
Is that where it is? Yeah, okay. I knew it was somewhere. I think we may want to try that so that it's a burglary into an occupied dwelling that's actually occupied. I mean, if somebody breaks into my house at 3 o'clock in the morning, I think I have a right to take some action. On the other hand, if they're breaking into my garage and there's nobody in there,
Well,
I'm not sure it would require the same action.
how about if they break in and you're not there, but then you come home and then
Well, that was an occupied dwelling.
it
I think
wasn't,
that's how we worded it.
we left it at that?
I don't remember exactly how we worded it, but I think we should look at that.
I mean, I don't want to
So
defend themselves in their own home when someone came in before, or came into their garage even. Scared.
I'm sorry.
Go ahead.
I think also a lot about the protests for justice that have been happening over the last year, and the incredible focus that people have placed on things like property damage. We've got people saying things like, well, it's a shame they're killing civilians in the street, but they really shouldn't be destroying property. As opposed to saying, well, it's a shame that property is getting destroyed, but we really shouldn't be killing civilians in the street. And I think that in this country, we have gotten to a point where we tend to center the protection of things in a way that we are now justifying a lot more harm than is necessary to protect sneakers and TVs and, rakes and shovels. And so I think about the implications of, occupied dwelling versus any kind of a structure, and what kind of leeway are we giving to people to protect persons versus property. And if we're talking about things like lethal use of force, we really have to ask ourselves what's worth killing over.
Mm-hmm. Yeah, especially because it's not a very nuanced piece of law. It says the person shall be blameless if they kill someone in the middle of a robbery or a burglary, and it's just cut and dried. It's like just get out of jail free if if you can say that you thought they were committing a robbery. So,
Sometime in the 80s, a representative proposed a bill that would have allowed you to shoot somebody for coming onto your property. And the headlines were of former Senator Aluzzi calling it the shoot your neighbor bill. And it's an interesting article, and obviously much before some of these current discussions, but certainly if somebody, we don't want to have a shoot your neighbor bill here. Or as you described it, suspicious, somebody's suspicious and they're breaking into my shed. So it gives me a right to do this. They might be just, who knows what they're doing. Again, thank you very much. I know you're very busy and I appreciate your comments. We'll try to find our way around to defining robbery in a better way.
All right, thank you
Thanks.
all very much.
Thank you.
Thank you. Well, that's another challenge.
It's another challenge. Right.
Well, the House has left us. In there, what did we have before?
What did we have before?
Was it burglary and robbery before? And current law?
Yes, it's in current law. I did have a suggestion about this section, if now is a good time for that.
Yeah.
I would be curious to hear from some other witnesses, prosecutors and defense attorneys about the extent to which this statute is actually used, or how it influences charging decisions, or if it's used as a defense in these types of cases. Because the suggestion I have would be to sort of line up the language with our jury instructions for self-defense. So at the end of subdivision 2, add language like if the person reasonably believed they were in peril of imminent bodily harm, or something similar to that, just to make it clear that they have to be in fear for their life in order to justifiably use deadly force on a person.
and reasonably in fear.
Yep.
Well, then if you did that, then why would you need to?
Right. I think that's why I'm asking. It would be interesting to hear from
Yeah,
prosecutors and
I mean,
defense
you
attorneys
could,
about.
one basically says that.
Yep.
It's a just and necessary defense of his, of the person's own life or life of, and I don't know why we leave it. What if I want to protect my
Marley.
dog from being killed? Can I do that? I mean, I don't want to use Marley. What if I want to protect, I'm having a cup of coffee with my neighbor. Can't I protect him too?
I would hope so.
He stopped over and somebody is, and I feel I need to defend him. This thing, one, limits me to certain members of my family.
That's a good point. I mean, I think there could be an argument that you could fear for your own life if you were having coffee with your neighbor and your neighbor was violently attacked. But I see your point.
No,
I would just want to be careful if we went down that road, because there's been a very polarized argument about whether or not good guys with a gun should be able to stop bad guys. And so you do have people who are, especially in open carry states, carrying pistols, and then they spot someone. They believe there was a case where someone was shoplifting and they pulled a gun to stop the crime if they were to kill the person. So in other words, in your situation, Dick, if we expand it to neighbors, how far does the concept of neighbor
Well,
expand.
if it's in two, and if we keep two, in the forceful and violent suppression of a person attempting to commit murder, sexual assault, aggravated sexual assault. And what we have to do is redefine burglary so that it's not just the shoplifting, because shoplifting is burglary, right? Is it?
No, I think that's different. The elements to burglary are different.
What about robbery? How do we define robbery and burglary?
Oh, yeah. Let me pull those up. Hold on.
I just concerned that we're going down a rabbit's hole here with burglary and robbery, and having it similar to committing murder, sexual assault, and aggravated sexual assault.
I would go back to Susanna's point. If the person is in fear for their life because of the burglary or robbery, then it seems like it should be here. If it's just that they're spotted stealing a thing, or in the case of George Floyd, accusedly passing a $20 bill that's counterfeit, should you be able to kill someone observing those crimes of commerce or property? And I would say no. It's just a question for me of which robbery or burglary involves more of the threat to the person occupying a dwelling, I guess.
Back in the day, they used to cool a pie out on the front porch.
Right.
Should you be able to murder somebody for stealing your aunt's pie, sitting on the front porch?
Then Huckleberry Finn would be dead.
I'm just, but that's robbery or burglary.
Yeah, yeah,
Is it not?
it is.
That's what that. So my whole point here, I think we're getting far afoot. I'm at fault for that. We need to better define burglary and robbery.
Definition.
Couldn't 1 and 2 somehow be combined so that you're talking about justifiable if there's a fear of your own life or somebody else's life, and then just get rid of burglary and robbery and all of that, and just if somebody is in fear of their own life or the life of somebody else, I don't know why we can't just combine 1 and 2 and make it.
Well, let me give, it wasn't death, but a former actual Patriot, New England Patriot football player, and another man came across a woman being sexually assaulted, and they grabbed the guy, attended to the woman, and held the assailant for the police. And of course, the guy was a big lineman, so he was 300 something pounds, and I'm sure that the assailant was terrified, but they held him. But if what this section 2 does is allows you to do that if you're witnessing somebody being attacked or sexually assaulted, no matter where.
And I think what Jeanette's saying accounts for that. And Bryn, correct me if I'm wrong, when you proposed your language, were you thinking about eliminating the list of crimes and just using the standard? Or were you talking about adding that to the list of crimes?
No, I was thinking about adding it.
I see.
But
I think Jeanette's right. It's for me at least, it has to have the element of threat to your life or the life of somebody else. Otherwise, why would we allow you to kill somebody if it's a lesser threat?
It's even wounds another, WOUNDS, wounds another, not just.
Yeah. When I look at the language we struck about mobs and riots, and it as originally written, it was just a super expansive statute. It was sort of like, there are all kinds of ways that you could be justified. Let's make sure we include them all. And I feel like now in hindsight, there it is. In hindsight, we're going back and looking at it and realizing that it opens up so many loopholes for the defense
But
and I'm really,
but 3 was limited to officers
Right.
or military.
right, but I mean, that's the, that was the language I was most surprised by when we saw it, because it seems if you could say there was a riot going on, you could do anything.
Yeah. Or if you were serving papers.
Right.
So I just sent the committee the 2 statutes that you're talking about
Okay.
now. So
Burglary
you
and robbery.
have a sense of what the elements are. But as you heard yesterday, robbery contains an element of violence, and burglary contains the element that you have to enter a dwelling or some other structure that you know that you are not licensed to enter. You don't have permission to enter with an intent to commit a crime inside the structure.
I guess that's the one that gets me, because that's the shed one.
Yep.
Yep. And it's also, it
It
includes.
could be 2 kids going into the dugout to smoke a cigarette.
Right. Yeah, if they're underage, it's a crime.
Well, you've got to have the intent to commit a felony, petite larceny, simple assault, or unlawful mischief.
Oh,
What's petite larceny?
petty.
What's unlawful
Petty.
mischief?
Petty larceny.
Petty
I got
larceny.
charged with that a lot. Or accused of it, I should say.
Yeah, we don't, I think. we've
Well,
got a-
isn't petty
a lot of
larceny
reps in-
shoplifting, Bryn?
Could be. It's a misdemeanor.
It could be, but again, that element is required that you have to either enter knowing you're not lawfully allowed to enter. It can't be something that's open to the public, like a store where shoplifting happens. Or you have to, I think there's another element that, so.
So you have to go into the dugout to steal the gloves that are there,
My brother and his
the baseball gloves.
best friend were caught burglarizing people's sheds. And they did it because there were things there that they could use or sell, and they weren't going to encounter anybody. So they were intending to have it be a form of burglary that would be the least disruptive to other people. But if I think back on it, he had to pay the money back to the guy that he stole from, and he had to go apologize to him. But what if that guy had killed him? Under this statute, he would have been perfectly justified. So I don't know.
Well, that's where Bryn's language would come in, that she
Yeah.
would add in the jury instruction, right?
Yeah.
I would like to hear, as Bryn suggested, from people how often this is used, if it's ever even used. Maybe we should just get rid of it.
I don't, again, if you could also send us the language we used in the expungement statute regarding the occupied building.
Sure.
To look at perhaps using that for the burglary. Yeah, once would be too many if it got used inappropriately. Yeah, I still think about it. There's no reason to believe that it couldn't happen here, like the case in Georgia where the guy walked into a building under construction, a house under construction, and was going to get water while he was out jogging, walking, and
Dick,
ends up dead.
can I,
Is-
oops, go ahead, Jeanette.
No, I was just going to ask, is this the statute that would be used in the instance of a domestic violence case where the either partner was in fear for their life? Is this what would be used, or is there something else?
I'm sorry, I didn't hear the first part of your question. Will you ask it again?
Yeah, is this the statute that would be used in the case of a domestic violence where one of the partners was in fear for their life? They'd been beaten repeatedly and now they were in fear for their life, and so they shot their partner. Is this what would be used?
I need to check the domestic violence chapter to make sure there's not some specific defense that's available there.
Okay.
I don't typically work in those statutes, so I don't know off the top of my head, but I'll check and let you know.
I just wondered if that was an instance where it would be used.
Hey. Simple little bill.
Simple little bill 3.0.
Yeah.
So I just sent you the language from the expungement chapter about occupied dwelling. And it refers back to the burglary statute. And it provides that that it can be expunged as long as it did not constitute a burglary into an occupied dwelling. And it refers back to the burglary statute, which defines occupied dwelling as a building used as a residence, either full-time or part-time, regardless of whether someone is actually present in the building at the time of entry.
That goes back to Alice's question, I think, about when they went in, there was nobody there, but then if somebody comes home.
Yeah,
But I
this,
guess,
this
yeah.
covers it. I mean, this is clear what it means. Even if someone's not there, it's an occupied dwelling.
Well, you could just, simplest thing would be to just describe, burglary into an occupied dwelling.
This is a good definition here. Because
Which one?
the one about occupied dwelling.
The one that Bryn just sent us?
Yes.
Yeah.
Yeah. It's very clear. So it's fine.
Just a question, Bryn. If I'm passing a neighbor's house and I see that I know they're away and I see somebody in their house, would this allow me to shoot them?
I see, I mean, that's the direct reading of it. I don't think that there's anything in the language that would require it be your own home, burglary into your own residence.
So what makes me uncomfortable about this is that it does seem to empower somebody who, if you think about Trayvon Martin was killed by a guy who wanted to be a policeman. And so he set himself up as a kind of self-appointed neighborhood watch person. And then he followed Trayvon Martin after he got out of a store and chased him down and struggled with him and killed him. And so I guess the problem I have here, and I would go back to Susanna's testimony, if there's an unarmed person and they've gone into a dwelling, they've committed a crime. I'm not justifying it. But do we want to say that a person is to be held blameless if they go ahead and shoot that person? May not be their house, may not be any threat to them. So that's where my problem with this piece lies, is it's not based on threat. That's why I liked what Jeanette was saying, because it feels like there should be a threat to the life or the health of yourself or another person. If there's not, that should be the test of whether you're allowed to kill them.
Are we talking about all people or just law enforcement? I'm trying to figure
about
out
All people.
So this bill deals with law enforcement, and are we now
They're
trying
also-
to?
No, it's what's in the bill right now currently as it came from the House, deals with justifiable homicide.
What am I missing?
It
So it's section
changes.
4 of the bill. Jill.
In the
It's on
course of,
page 13 of your hard copy.
Page 6 of the,
remember, Joe, in the course of putting together 219, I think it was, or 119, we realized that the justifiable homicide statute had wildly expansive language, and we were going to hold off on it, but then the House went ahead and struck 4 or 5 sentences from it. And so now we're just continuing that. discussion of it, I think.
I don't have my hard copy here. I'm at home.
And 3 does deal with law enforcement, but 1 and 2 deal with everybody.
What was the law before this was changed? Was this whole thing changed or?
No,
And
no,
spout?
it's in the law, burglary and,
Yep, it's there already. And if you remember, the idea was to change that subdivision 3, which sort of has this probably unconstitutional provision that law enforcement can kill or wound another in the course of their duties. And so the original idea was to change that provision. And then as the committees were looking at the justifiable homicide statute, you realized that there was quite a bit of outdated and odd language. So you updated the language in subdivisions 1 and 2 without really amending the scope of those sections.
Oh, I see.
So now you're talking about amending the scope of those sections, because I think you're mostly thinking of it in the context of law enforcement when you initially.
so could you try an amendment for us to look at the next time we take the bill up?
Sure.
That would make it burglary into an occupied dwelling. And putting your language of jury instruction in.
In addition.
Yeah.
Okay.
So we can look at something as opposed to just theoretically.
Will do.
The building, the definition for the purpose, the burglary into an occupied dwelling is the same as a residence, not a shed. Okay. The House passed a bill on hate crimes. Page 428 that Bryn drafted. That
What
was
number did you say?
428. It basically, all it does is add, or the National Guard to you would have an enhanced penalty.
It also removes an element that the prosecutor would have to prove in order to successfully bring.
Yeah, well, I should have you walk through the bill.
Okay, I'd be glad to. Does everybody have it in front of them, or would you like me to
Yes.
put it up on the screen? Okay. So as Senator Sears just mentioned, it is pretty straightforward, actually. The changes that it makes to the hate motivated crime statute are pretty straightforward. So this is the section of law that a prosecutor can bring in addition to another crime as an enhanced sentence. So just adds a subdivision or a subsection heading there for enhanced penalty. And then you'll see down below, I don't know if you have line numbers on your document, but
We see it.
there's a struck through word maliciously. Can you
Yep.
see it, Senator Nicka?
I can't.
Okay.
I mean,
Would you like me to share my screen?
I
Why
would
don't
like-
you share the screen?
Okay.
The screen.
The screen,
Lord.
scream?
Screen, the screen.
Be very
Oh.
quiet.
I thought you said scream.
I did. I
Yeah.
meant screen, and I said
I
screen.
know.
I just have to pull it up. Give me one
I
moment.
was trying to imitate, what's his name?
Elmer Fudd.
No, the scream.
Oh, Monk.
Yeah.
Monk's the scream.
Okay, hold on. Let's see if
Quick story. I waited on Elmer Fudd one time. I was working in a restaurant and the hostess said, "I just sat you Elmer Fudd." And I laughed. And I walked over to the table and it's this little short man with a little hat. And he looks up at me and he goes, "Hello."
Okay. Can everybody see H428 now?
Yes.
Okay. So you'll see that what the bill does is it strikes the word maliciously right here, partway down the page. So this essentially removes the element that a prosecutor would have to prove that the person's conduct was motivated by malice. So instead of having to prove that the person's conduct was maliciously motivated by the victim's protected status, the prosecutor would just have to prove that the underlying crime was motivated by the victim's protected status. Also, they've added the words "or the National Guard." It adds the National Guard to the categories of protected classes under this enhanced penalty. So the U.S. Armed Forces are the Army, the Marine Corps, the Navy, the Air Force, Space Force, and Coast Guard. And then the Army National Guard and Air National Guard are reserve components of those services, and they operate in part under state authority. So the National Guard really has a dual federal and state role. So the House Judiciary Committee wanted to specify that the National Guard is included to just eliminate any uncertainty about that, to ensure that the statute covers those individuals. And then subsection B adds to the hate crime statute an annual report requirement from the executive director of states attorneys and sheriffs and attorney general. And that annual report is going to come to the judiciary committees and detail for the prior year those incidents that are reported to the National Incident-Based Reporting System that detail categories of bias motivation and types of offenses that were coded with an offender bias motivation. Also, that report has to detail any convictions that were established in the criminal division for which the sentence was enhanced under the hate motivated crime statute. And also any reported bias incidents that resulted in a final judgment in the civil division. And then subdivision 2 just creates some parameters on this report. It says, to the extent feasible, the report shall include demographic information about the defendants and protect victim confidentiality when the statistical information is maybe identifying. So if there's such a small number that that victim identification is possible, we should protect that information in the report. So just a little bit of background, this reporting requirement was initially a part of H128, the Gay and Trans Panic Defense Bill, as it was introduced. But the committee wanted to change it, amend it, and work on it a little bit more, so it got moved to this bill.
It seems, is that information readily available, or is that going to take a lot of research to get some of that information?
So the language was worked on with several stakeholders that would be responsible, including the Attorney General's office and the state's attorneys.
Mm-hmm.
So they really worked on crafting this language. So I'm sure you'll hear from them when you hear about this bill. But I think that this information, there was testimony that would be challenging to get it, but there was some pushback from the committee that they really wanted this information. I think it's important to find it in whatever way we can. So this was the language that they came up with that they'll be able to gather. So I'm sure you'll hear from them.
So the real issues are the striking the word maliciously in this and in section 2,
right?
Burning cross or other religious symbol.
Right.
Can I ask a question about that?
So this whole report thing, could you repeat what? Go ahead, ask a question about burning crosses.
Well, my question is, clearly we know the origins of why we don't want crosses burned, but why would it be limited to burning? If somebody hacks apart a religious symbol at a church or someplace else, I mean, why would we limit it to burning? I'm just curious. I know that was what it was, but.
So cross burning has been found by the U.S. Supreme Court to be constitutionally outside the protection of constitutional speech because it's intended. There's a long history of cross burning as as intending to threaten the life of certain people. So it's sort of been specifically targeted as non-protectable activity. So state can criminalize it.
All right, I get it. That answers my question. Thank you.
Sure.
Why do we need this report? Yes, I should ask the witnesses.
Yes, you may also want to hear from maybe a member of the House Judiciary Committee. I can tell you that the testimony was that that they, just like all of the other bills that are moving this year and in previous years about really wanting to make policy based on data, they felt like there wasn't access to this type of information and they wanted access to it.
Well, but they went ahead and changed the law. I mean, if you're really looking for data to make the law, then you wouldn't have changed the law until you got the data. Not arguing with you, Bryn.
I know. I'm just trying to be clear. And I think that what I'm trying to say is this report initially came up in context of the defenses based on victim identity bill. So it was really initially started out as wanting to collect information about any kind of cases that may fall under that bill, those kind of defenses based on a victim's gender identity or sexual orientation. So I just want to be clear about the genesis of it.
May I ask a question about this report?
Yep.
So just remind me what demographic information covers, and also if this, all our reports, because this says annual report, does that mean it isn't subject to the 5-year sunset?
Right, that's correct. And also, if you'll note, it's placed directly into the statute, so it would be an ongoing requirement.
Okay. And remind me what demographic information covers.
Well, that would be like the age, the race, information like that of the defendant.
Would it include things like if the place where you lived, or
Yep, probably so. It would be information that the courts have access to. So I imagine that their residents would also be included. Yes.
Okay. Thank you.
We have listed as witnesses the Attorney General, state attorneys, ACLU, and Rebecca Turner, and Zana Davis, and somebody from the Human Rights Commission. Sound like a quick thing we could do next Friday, Peggy?
We have from 10:45 to 11:30 free.
Yep, that sounds like a way to fill that if Bryn's available.
I don't think it's going to go as fast as we think.
Why?
Because of the, I think
Why?
the other part's easy. I think the report is the piece that's,
Well, take the report out.
yeah, it's okay with me. Well, I mean, it is a way to get data, but this is like overboard.
Right, so let's take the report out and focus on
Actual expense.
removing the word maliciously.
There's a difference between requiring a report and asking people to report to you about certain data that they have. And when we require a report, it's this big deal, and people put it together and they submit a report, but sometimes we can get the information we want by just asking people to report to us.
I'd rather focus on taking out the word maliciously, and I don't know how hard. I don't see that adding the word or National Guard is a real. It seems like that's technical.
No problem.
So the focus would be on the word malicious, and you're taking out that word. What does that do? That's what I was planning on looking at, and not necessarily if we take out the report, then the House would have to argue back. I think we're all Senator White for the last 5 years, or maybe even longer, has been on a war against reports.
Yes.
You know, they're expensive to put together because it takes hours and hours of research to get all the information that people
And they
don't.
don't get read 9 times
They-
out of 10.
Right. And oftentimes you can
What time
just
are we supposed to be on the floor?
one.
One.
Oh, this is Thursday.
Yeah.
I said Friday, so I was hoping this was Friday. I was so hoping this was Friday. Okay, couldn't get away with it. So I would need to be, is everybody okay if we consider taking out the report unless we hear good reason to put it in?
Sure.
I think it's, man, there's so many reports coming in that I don't have time to read half of them.
Can we think about doing that for S30 if it comes back to us with changes from the House?
No.
I would vote for getting rid of that report.
You
This
do
one-
realize who's in charge of authoring it, right?
Well, let me just put it to you this way, Joe. I would be very careful about how you author that report, because if something happens next year at the State House, they're going to go immediately to that report and what you recommended. So it's not something to be treated lightly.
Oh,
I don't think you understand the gravity of what that report's
I think that
drafting
after
takes
the-
into account.
I think that should the report become law, that you and Philip need to have an in-person lunch and discuss the contents of the report.
And he's buying.
Fair
Well,
enough.
that, I don't know.
Weigh in on that piece.
But so our focus is on dropping the word maliciously and adding the National Guard. I don't see that. That sounds like technical. Is that correct?
Senator Sears, you know how you complained about having so many bills?
Yeah.
Half of them were introduced by you. I just went through our new stack of bills.
But by request of somebody.
That
Oh.
reminds me of, we had a chairs meeting maybe 8 years ago, and you, Mr. Chair, were arguing that there should be a strict limit on the number of bills,
There should be.
but then you had like 3 times more.
As long as the rules allow it. Many of those bills were requested by administration or someone else.
Do you
I
remember
just put my
when,
name on them. All of those. There's none of them that are my brilliant idea, except for S5.
do you remember when Clem Bissonette introduced a bill about nakedness by
No.
request?
Oh,
And he
yeah, yeah.
didn't put by request in the parentheses, and he got so much grief.
Was that because of the nudity in Brattleboro?
No, I don't remember what it was. I think there was some swimming hole or something that,
Oh,
I
But-
think
wanted
it's time to